Obliged, Lily. Just before I resume, I wonder if I could deal briefly with one query that was raised this morning about the genesis of the Inquiries Act 2005 and whether it was related to the Pat Finucane case. Yes. I think what we need to do is undertake a comprehensive review of all the papers, just to come up with as far as we can, a complete list of the references to indicate the reasons behind that Act. There are two passages that are relevant for present purposes that can be found at Appendix 3, page hard copy 744, MS 1060. That's a statement made to the House by Mr. Paul Murphy, Secretary of State. And also at Appendix 3, pages 747 and 748, MS 1063 and 1064, which is a letter from Paul Murphy to the family's solicitor, both of which tend to indicate this was connected to the Pat Finucane case. I have to also say there's another passage we've come across at Appendix 3, page 753, MS 1069, which is a note from Jonathan Powell, Prime Minister's Chief of Staff at the time, to the effect that it was also related to difficulties encountered in some other cases, like the Shipman inquiry. So that's why I think we should do our best to prepare a comprehensive list of the references to this.
Yes. It will be necessary to hold the inquiry on the basis of new legislation which will be introduced shortly. And you suggest that suggests a causal connection.
Yes, we related also to the letter at MS 1063, which is a reply to a letter from Mr. Madden, solicitor for the family, which indicates that the purpose of this Act is to deal specifically with the Pat Finucane case, and there's a reply which doesn't demur from that proposition. Okay. But that's why I'm drawing the Court's attention to Mr. Powell's note, because that indicates it may not have been as clear-cut as that, but we would like the opportunity to look at all the references in the papers to see what the burden of the evidence shows. It was certainly our understanding that it's largely, if not entirely, to address the difficulties identified as being involved in conducting an inquiry into the death of Pat Finucane.
I had one reference, if you've got it conveniently there together.
Yeah, it'd be useful to have them all together, thank you.
786, perhaps, in Appendix 3, in the hard, which is... It's a letter that starts at MS 1101, and the relevant part is the final paragraph on 786 or MS 1102, where it said the Act was a general reform measure introduced by the Department of Constitutional Affairs following a 3-month consultation exercise in 2004 and a study carried out by Sir Roy Beldam in 2002. It's updated and improved the whole statutory framework for public inquiries.
See, my recollection was that there was a wider call for it, and it wasn't specific to this case. That is tending to suggest that was the case, although that doesn't have any effect on the fact that it was felt that the new legislation had to be passed before it was appropriate to hold this inquiry.
Well, the coincidence in time and the fact that the surrounding facts suggested to us that was the main reason for it. But the reason I've drawn attention to Mr. Powell's letter to indicate that there's some evidence that it was for other reasons as well.
Well, whether it was to deal with the general or not, as my lady points out, it was conceived to be necessary to introduce the legislation in order to deal with the inquiry into Mr. Finucane's death.
Yes. It was said that it couldn't take place until the new legislation was in place, whereas other inquiries, which may have faced similar problems, did go ahead, notwithstanding the fact that they were under the 1921 Act.
Was that even after the introduction of the 2005?
No, before that.
Before that.
Once the 2005 Act repealed the 1921 Act.
Yes.
I had been dealing with our third heading, Article 2, and the court will remember that there are really two elements of Article 2. The first is, does it apply at all? The second is, if it applies, what's necessary to comply with it? I think I've dealt as much as I need to with the first question, does it apply? And that's why I was referring to McCaughey, Yanovich, KU, and then to some extent Edwards. The next question is, as for what is required, if it applies. We say this is one of those cases which, by reason of the admitted gravity, requires a proper public inquiry, not just a police investigation. It's one of those cases where nothing less will do. And of course, that's what the state itself had already decided in 2004, that nothing less than a public inquiry would do, and that was repeated by successive secretaries of state, that what was required here was an inquiry with a senior judicial figure held in public with powers of compulsion and the participation of the family. Those are all elements that weren't present in the Stevens police investigation. And that decision, of course, to have such an inquiry corresponded with the standards applicable under the United Nations instruments, which I'll deal with briefly now. In particular, at volume 4, tab 56, that's page MS 4792, the court will find the UN principles on the effective prevention and investigation of extra-legal, arbitrary and summary executions. And specifically at paragraph 9, page MS 4793, it said there should be thorough, prompt and impartial investigation of all suspected cases of extra-legal, arbitrary and summary executions. 10, the investigative authority shall have the power to obtain all the information necessary to the inquiry. 11, in cases in which the established investigative procedures are inadequate because of a lack of expertise or impartiality, because of the importance of the matter, which is this case, or because of the apparent existence of a pattern of abuse, which is this case, and in cases where there are complaints from the family of the victim about these inadequacies or other substantial reasons, governments shall pursue investigations through an independent commission of inquiry or similar procedure, which has various powers that are specified there in more detail. There's also a subordinate instrument known as the Minnesota Protocol, which can be found at tab 55 in the same bundle of authorities, starting at MS 4767. This is the manual on the effective prevention and investigation of extra-legal, arbitrary and summary executions. I don't propose to dwell much on this, but I would draw attention to page 15, first of all, of this document at MS 4783, which refers in the middle of the page to guidelines for establishing a special independent commission of inquiry. And that's dealt with in more detail in section D at page MS 4786, commission of inquiry. In cases where government involvement is suspected, an objective and impartial investigation may not be possible unless a special commission of inquiry is established. And then there's a section dealing with the factors triggering a special investigation at MS 4787, the next page. Factors that support a belief that the government was involved in the execution and that should trigger the creation of a special impartial investigation commission include, then there's a list of factors including 2, where the modus operandi is recognisably attributable to government-sponsored death squads, and 3, where persons in the government or associated with the government have attempted to obstruct or delay the investigation of the execution. Likewise, under B, on the same page, B3, the importance of the matter or the apparent existence of a pattern of abuse. Obviously, that can be traced back to the UN principles themselves. And then dealing with the power of the Commission at MS 4788, page 20 of the hard copy. There's reference to the powers required for such a commission, including the authority to compel testimony under legal sanction. That was the protocol in place at the time of this decision. For completeness, I should say that's been updated. There's now a 2016 Minnesota protocol. We have hard copies of this available. Again, I don't want to spend a lot of time on this, but I would... Yes.
Thanks, Terry.
Thank you. The court will see at main internal page 1, chapter 1, under the head aims and scope of the protocol, paragraph 2A, where it applies to situations where the death may be attributable to the state, and gives examples including use of death squads suspected of acting under the direction or with the permission or acquiescence of the state. And the different provisions here, paragraph 8, section B, paragraph 10, deals with accountability and remedy. Satisfaction includes government verification of the facts and public disclosure of the truth, and accurate accounting of the legal violations, sanctions against those responsible for the violations. 11, information on the causes of the killings and to learn the truth about the circumstances. Section D, elements and principles of investigations. But paragraph 24, in the middle of the paragraph, investigations must be capable of ensuring accountability for unlawful death leading to the identification and, if justified, by the evidence and seriousness of the case, the prosecution and punishment of all those responsible. And there's references to the minimum steps required, including obtaining evidence from witnesses and determining individual responsibility. This is paragraph 25. 26 refers to the need to identify the officials in the chain of command who were complicit in the death. It should also seek to identify policies and systemic failures, identify patterns where they exist. 27, in the middle of that paragraph, the mechanism must, at a minimum, have the legal power to compel witnesses and to require the production of evidence. 28, towards the end, inquiries into serious human rights violations such as extrajudicial executions and torture must be conducted under the jurisdiction of ordinary civilian courts. 38, the internal page 10 refers to the minimum requirements. And 39, in specific circumstances, the state may establish a special mechanism such as a commission of inquiry. Those seem to be the relevant paragraphs for present purposes. And we say that Sir Desmond de Silva's review was never going to be more than what officials recognised it to be, an administrative review, as is said at MS 1625, or Corey 2, MS 1335. That completes our submissions in relation to the third heading. The fourth heading is respondents' submissions. Now, what I propose to do is to go through this as quickly as I reasonably can, identifying some particular matters that seem to require a response. Clearly, it should go without saying that we are relying on our written submissions, and the fact that I don't mention anything on oral submissions shouldn't, of course, be taken as an indication that we've either abandoned the submission or we are placing less emphasis on it. Given the constraints of time, we have to restrict ourselves.
You're still relying on legitimate expectation, presume?
Oh, yes.
Are you going to deal with that?
Slightly alarmed that your lordship should say that.
Well, no, it's only that it hasn't been mentioned yet, and I assumed you were going to be coming to it at some point.
Well, it was actually mentioned in the second heading, really, about the justification.
Yes.
And I hoped that I had said something like we were relying on the reasoning of the court below to establish that there was a promise. The first part, stage one.
Stage one was why the inquiry was promised, yes.
That was the first part of the submissions, but also in relation to the second heading, why the decision to renege wasn't justified.
Yes, that's also
we have sort of stepped over stage one of the process, and we're relying on the reasoning of the High Court and the Court of Appeal to the effect that there was a promise without devoid of relevant qualifications.
Yes.
Moving straight to the second stage, which is it just justified to renege on that promise?
Yes.
So that was what section 2 of the
You're
submission.
going to deal with
submissions
what
is
the
about.
other side said.
Sorry, Lord?
You're going to deal with what the respondent said.
Yes. I'm coming to United Policyholders. So the respondent's case can be found in the core volume. And as I say, I'm going to deal with some miscellaneous points, and this is necessarily going to be a lot more fragmented and tedious. But as we go through it in the introduction, paragraph 7, it's to be noted at the outset that this murder and the surrounding circumstances have been the subject of the most detailed and intense investigations. Well, there has been a lengthy investigation by Lord Stevens in particular, but obviously that was not public. There were no powers of compulsion. The prime culprits weren't even interviewed. In particular, the handler of Mr. Nelson weren't even interviewed, let alone cross-examined on behalf of the family. And in particular, no one was ever held accountable by Lord Stevens. We've seen Lord Stevens' overview. We don't want to be critical of Lord Stevens particularly, but the overview was brief in the extreme and does not provide anything like the kind of accountability or information that could ever comply with an Article 2 investigation or could ever be regarded as satisfactory. So it's not just a question of whether a lot of time has been spent on an investigation. The question is whether it's been effective. Then section 3, starting at paragraph 17, deals with the facts and the evidence. And it's said at paragraph 19 that no objection was raised in either court below about the form of evidence. Now, we didn't object to the admissibility of the official's evidence, and we still don't object to the admissibility of the evidence. But what we do say, and what we did say below, was that this isn't sufficient to constitute evidence of what was in the mind of the decision makers and what they identified, particularly the Secretary of State, identified as the factors of the 6 factors that he had recited in Parliament, and the way in which any one of those 6 factors was so compelling that it overrode the requirement to comply with the promise. And those points were made forcefully in both the courts below. And we drew distinctions between, on the one hand, what was being said by officials, and on the other, what was being said by ministers. Because what was being said or believed or thought by ministers is what is important. In any event, this point that we now make in this court specifically arises from the need that's always been present to examine closely and anxiously the evidence supporting the supposed justification for the decision to renege on the promise. There's nothing new about this. We've simply flagged it up, perhaps in more express terms, that as a general rule, query whether this should really be acceptable at all, quite apart from this case. 21, it's said that the appellant has never before, in the second sentence, the appellant never before expressed any desire to cross-examine and made no application to that effect at any stage of the proceedings. We couldn't ever cross-examine these decision makers. When I say these, of course, although the Secretary of State is the only formal decision maker and respondent, we're including the Prime Minister as one of the essential decision makers as a matter of fact. But the main point is, because they did not swear affidavits, as a matter of law, we weren't entitled to apply to cross-examine them about their reasons. And that's based on the Williamson case, which we've referred to in the submissions. Moreover, the appellant's initial grounds of challenge included a claim of bad faith against the Prime Minister. That was a specific allegation in relation to words used at the meeting with the families, and it was decided on a factual basis that, taken as a whole, the evidence did not warrant the allegation, and that particular allegation was withdrawn, but we haven't withdrawn the allegations that the ministers have failed to deal with this matter properly. Paragraph 22, the appellant accepts that it will be appropriate for affidavits to be sworn by officials in many cases, but offers the court no suggestions as to how those cases may be defined or what should be the distinguishing features. Well, where the decision is that of the minister, and the reasoning has to be that of the minister, and where officials have no direct knowledge of that reasoning, ministers should be obliged to swear affidavits. And a good example in this case is that gap, complete lacuna in the evidence, where 1 minute the Secretary of State says there are, applying these 6 public interest factors, there are only 2 options here. And the next minute he's saying, well, actually my preferred option is something entirely different, involving a non-statutory inquiry, which of course came from the Prime Minister's suggestion, we say, but there's no evidence at all about where that came from or how the Secretary of State arrived at that position. Then the last sentence of paragraph 22, nor is it said that the documentary evidence sequence and the statements were anything other than sufficient, without more, to enable the issues arising to be properly and fairly determined. Well, we are saying that, but if it may be that what my friend is saying is that we are recognising that the issues were properly identified by officials. If that's all that's being said, well, we agree that the issues were properly identified by officials. Our complaint is that there's no evidence to indicate, no proper, reliable evidence to indicate how the decision maker or makers arrived at their conclusion. And they haven't done enough to satisfy the court, as they are required to do, of the reasons for coming to the conclusion that the justification was compelled essentially by overriding public interest factors. Then section 4, starting at paragraph 24, substantive legitimate expectation. There's reference here to United Policyholders Group, and in particular to judgment of my Lord Carnwath. Now, in that judgment, there's a suggestion that some kind of detrimental reliance is required. And I have to say, with great respect to my Lord Carnwath, this, of course, is a dictum that's completely obiter.
Sorry,
it was. Sorry, Lord?
What did you say?
Oh, it's obiter.
Oh yes. No, I was on my own. I mean, can I just make clear that one of the things I was trying to do there was to draw a distinction between the sort of legitimate expectation you had in a case like Paponet, which is where you have a representation made to a particular class of, defined class of people, in that case the taxi holders, where there is detrimental reliance. And I was distinguishing in that and the sort of policy statements, which it seemed to me were of a different order. And you don't expect there to be detrimental reliance when government issues a policy statement, because because it's made to the
Yes.
public at large. But it seemed to me, and there's authority that policy statements can have legal effect, but on the other hand, they can be departed from. But that was a distinction I was trying to draw, which hasn't been drawn in previous cases. There's been a tendency to align the two. That was the point.
Yes, Martin. Well, I can see that.
I mean,
But
obviously
insofar-
made an issue here about whether this promise was a promise made to Mrs. Finucane personally or specifically, or was made as a matter of a general policy made to all those who are interested in a matter of major public importance.
Yes, Martin, I can see that. But insofar as the respondents are seeking to rely on this passage in the judgment in support of the proposition that detrimental reliance is required, I have to respectfully point out that the current leading authority is against that proposition. The weight of authority is in support of the proposition.
You're perfectly entitled to say that I was on my own in saying that. I remain unrepentant.
Yes, I'm sure, my Lord.
But I mean, that may be of no interest to anyone.
Not just on your Lordship's own, but this arose in a case where it wasn't the issue. And for that reason, I say respectfully, it was over not only not the issue, but wasn't apparently argued during the case. I can see how it's a debate that may have to be had at some stage in the future, but it was not a debate that was had in that case. And therefore, without the benefit of argument, we respectfully suggest that the current authorities are still the leading binding authorities.
So what's your best
on that
authority?
issue.
What's your best authority then?
Well, Papanet probably is the obvious leading authority, as well as Banco and Coughlin, where it's clear. I mean, it's repeated time and time again.
But the issue of detrimental reliance was over to there in the sense that they were concerned with a different factual basis.
Yeah, there's no doubt that there are cases in which which lend themselves to the elevation of the importance of detrimental reliance, but there are other cases where it may not be appropriate to even introduce the concept of detrimental reliance. But in any event, it's the authorities seem, in our respectful submission, to be clear that detrimental reliance is not an essential element. The absence of detrimental reliance may be a factor that's taken into account in determining whether it's so unfair as to be a conspicuous abuse of power.
Yes, I mean, clearly it's relevant.
It clearly is, yes. I don't dispute that.
No, but you say it's not a component of the doctrine.
It's not a sine qua non.
No.
Which,
you say it doesn't come into the first stage. Was there a promise made which gave rise to legitimate expectation?
exactly, Lord. Yes. And of course, it wasn't argued in this case that detrimental reliance is required until this point. So then that takes us to the second stage, the justification stage. And at paragraph 37, it's indicated that the degree of intensity of review will vary from case to case depending on the character of the decision. We agree with that. There's a reference to a passage from Judgment of Lord Justice Laws in which he says the facts of the case, viewed always in their statutory context, will steer the court to a more or less intrusive quality of review. We don't disagree with that. But then over the page, towards the end of that quote in paragraph 37, it said, the more the decision challenge lies in what may inelegantly be called the macro-political field, the less intrusive will be the court's supervision. Well, there are two aspects about this. First of all, it has to be genuinely in the macro-political, the decision itself has to lie genuinely in the macro-political field before the consideration, any weight could be given to this proposition, as opposed to there being political elements, such as the risks associated with the fallout after the event, or handling, the political handling issues, which are not properly so-called part of the decision itself or the reasons for the decision itself. And then secondly, even if it is genuinely in the macro-political field, it doesn't always follow that their review will be less intrusive, because it really depends on the need to engage in anxious scrutiny, because the macro-constitutional issues may trump the macro-political issues, depending on the facts. So it doesn't always follow that just because the government invokes politics and suggests that there are multi-layered, complicated issues of policy involved here, that the court has to step backwards. There has to be some analysis of the merits of that claim in the first place. And it may be that whether they're macro-political or not, they require examination. And then there's the application. Sorry, actually just passing 42, there's a last reference to the detrimental reliance point and refers to the previous case law, focusing on detrimental reliance. The current and leading case law makes it clear that it's not required. So then my friends go on to deal with the application of these principles, deals with whether there was a clear and unambiguous promise. I don't think we need to deal with that for the reasons we've outlined. And the next section then is at page 26, starting at paragraph 67, overriding public interest considerations. It says in the middle of that paragraph, the court is the final arbiter of their sufficiency, and we underline that. But we disagree with the second part of that sentence, that the government is entitled to a broad margin in making its assessment in a context such as the present. It suggested that the standard of review is rationality. Well, of course, the standard of review is proportionality in circumstances where the issue is whether this is so conspicuously unfair as to amount to abuse of power. And it's the court that decides that issue. And fairness, of course, is a matter of law, always a matter of law for the court. Then at 70, it said that Mr. Justice Stevens identified each of the different factors, and in substance, the appellant contends that his analysis stopped there, which we say is the case. Paragraph 166 is the only paragraph in the entire judgment of Mr. Justice Stevens which deals with this question of the decision maker identifying the factors and the extent to which they are sufficiently compelling to override the promise. This submission goes on to say, however, in the paragraph immediately following, he also identified the precise documents and materials by which the analysis of these factors have been briefed to ministers. Well, that's exactly the point, that there's lots of material showing how these issues were briefed to ministers or discussed in briefings to ministers, but precious little to indicate directly how they were weighed by ministers, which is what they were required to do. 72, both courts relied primarily on the best evidence of how the public interest factors had been considered by ministers. Well, as I say, with no evidence from ministers, or even anyone in a position to know how they had been weighed by the ministers. And again, there's reference here to the very detailed briefing papers, and we take no issue with the detail of the briefing papers, as we make clear. And reference to the briefing papers doesn't take the respondent anywhere, because it's not the official's decision. It's not their reasoning that counts. Then 78, this is in the section that deals with the period between 2004 and 2010. The fact is that the family chose to reject the inquiry procedures which Parliament had chosen to enact. Well, as I say, so did judges, such as the Lord Chief Justice of the time, Lord Savile, expressly, and this is in the papers, expressly indicated that he wouldn't chair an inquiry with these procedures. And the government, of course, as we've seen this morning, the government wasn't even sure that they could get a judge who was prepared to chair this inquiry. In 79, it remains, this is at page 30, MS 243. It remains unclear what position the family would adopt to an inquiry under the 2005 Act in which the possibility of a restriction notice remained. The family has made it clear, and I make it clear again, that the family would accept an inquiry under the 2005 Act, which of course includes the right to issue restriction notices, despite their concerns and reservations about that. But more importantly, it was known to the government at the time they made their decision that the family had already decided that they would accept an inquiry under the 2005 Act. The court will find that, I don't need to open it out for present purposes, but the court will find that in Appendix 4, page 1034, paragraph 7, in fact I think I have to refer to it, but do you have the electronic page number? Sorry. Appendix 4, 1034, MS 1354, paragraph 7, and this is in the briefing paper by Cabinet Office officials to the Prime Minister. It was said the family now appear to be ready to accept the broad 2005 Act framework. And also at 1039, a separate Cabinet Office paper. This is 1039 MS 1359, paragraph 4. As a result of recent discussions with the family, we have a better sense of their position. Their overarching objective is to hold the government to account publicly for the role they believe the state played in Mr Finucane's death. And then further on down that paragraph, whilst they have previously had reservations about the 2005 Act, they have now indicated they would accept an inquiry under that legislation under certain conditions. These are the conditions about Baha Musa protocol, which had been understood could be applied and had been applied in Baha Musa. And also at same Appendix 4, 1042, MS 1362, halfway down the page, despite their previous opposition to a 2005 Act inquiry, the Finucane family have since indicated they would now be prepared to accept one under certain conditions. And 1055, paragraph 4, there are three options on the table. One is to agree to the demands for a full judicial inquiry under the 2005 Inquiries Act. The Finucane family previously rejected this as allowing ministers too much power to prevent public disclosure, but now say they would accept this.
And what paragraph is that again, please?
That's paragraph 4 on page 1055 in the hard copy, 1375 in the electronic copy.
Thank you.
The point is that the family want this inquiry to work and would take part in it without, in fact, any preconditions, despite their continuing reservations about the correctness of this power. And then there's discussion of the substantive public interest considerations. 81. The Secretary of State's announcement to the House of Commons on 11th November 2010 identified 6 factors which provided the analytical framework for the ultimate decision. But it is manifestly not the analytical framework for the ultimate decision. We've got the meeting record at Appendix 4, page 1062, that I took the court to earlier, MS 1382, the letter, recording what took place. And there's no analytic framework there that bears any resemblance to the 6 factors that were identified by the Secretary of State at the beginning of this process. And then paragraph 83, MS 244, there's a brief overview of the issues raised in relation to the 6 factors included. Sorry, in relation to the 6 factors, and they're set out there. I don't need to go into any of these because the same reason. This doesn't help in assisting an understanding of why and how the decision makers came to their conclusion, because this all comes from officials, what officials were saying. And again, paragraph 84, page 32, MS 245. A further detailed analysis was prepared by ministers in advance of their July meeting, and it's a reference to that. Again, doesn't take the respondents anywhere, because this is all about what the officials are saying, and tells us nothing about what was actuating or motivating the decision makers. Then 87 refers to the meeting of the ministers on the 11th of July and sets out the record of that meeting, which I've already addressed. And then at 89, it says, focusing for present purposes simply on three of these factors. Costs. It says in the middle of the paragraph, the government was also entitled to approach the issue from the starting point of its general policy. The starting point in our respectful submission was the commitment to have an inquiry. The starting point was the fact that the government was obliged by virtue of Mulcahy to have an inquiry that complied with Article 2. The government's starting policy seems to be its general policy of no more inquiries. And this is a submission that appears here in the legal submission. It's not actually anything, it doesn't appear in the letter itself. There's no reference to the general policy. We know from an earlier letter that what the Prime Minister was saying was, given our policy on inquiry, this is the start of the process. Given our policy on inquiries, we shouldn't have this. We should be looking at some sort of non-statutory inquiry. But in the decision letter itself, or the record of the decision itself, surprisingly, there's no reference to the policy that we say led to the decision. Instead, there's a reference to the primary objective must be to find the truth. That was supposed to be that was stated to be the starting point, although we say it manifestly wasn't. And it says at the bottom of paragraph A, the individual merits of this case were thoroughly considered. Well, we say that's exactly what's in dispute, and there's no direct evidence that the ministers thoroughly considered the individual merits of this case, or in particular the gravity of the case, or Judge Corey's conclusions as to why an inquiry was required. None of that features in this record.
Would it have been open to the respondent to file affidavits from the various officials deposing to the fact that the minister had given consideration to these factors and for this reason or that reason had decided not to hold an inquiry?
We say no, my lord. We say because this was a decision that had to be made by the Secretary of State himself, and because the Secretary of State had been advised by his own official, Mr. Threlfall, in terms that you are the person who has to make this decision, you have to weigh each of these factors individually, you have to decide on the relative weighting of these different factors, and you have to be the one who decides that all these factors are sufficiently compelling to override the requirement. It's only the Minister who can provide that evidence. It's not sufficient for Mr. Threlfall to say, I gave him all these briefing submissions in which I set all these factors out, and he eventually ended up with the option that it would have a non-statutory inquiry, and I infer from that in some way, which is all that an official can do, that...
Well, if he was told, it's not a matter of inference. If he was actually told by the Minister that these are the reasons that I decided not to hold the inquiry, is he precluded from deposing to that in affidavit?
We say yes, my lord, because
it's hearsay.
It's hearsay, and it's not the best evidence, and there's no reason why the Minister can't do it. It's different where they're departmental decisions that are nominally made in the name of the Minister, but actually are departmental decisions. Officials can, of course, say what the decision was and why it was made, but where we're talking about a very particular decision that has to be made as a matter of public interest, weighing public interest factors concerning a matter of great public concern, the only evidence that can be given of that is the evidence of the decision maker. Especially when there's an array of factors that have to be weighed and given relative weighting and have to be weighed against the commitment that's been made in the past and matters of that nature. It's simply not good enough.
Is the fact that evidence is hearsay a complete bar nowadays?
No, it's not, my lord. Obviously, in judicial review, we all know this happens in judicial review.
No. So when you say to Lord Kerr that an official cannot depose as to why a minister decided a matter, then hearsay isn't itself a bar.
Well, it's one of the reasons why it's not sufficient.
One could say it could be, one could have better evidence.
Technically, well, we all know that technically, hearsay evidence is admissible, and it appears all the time in affidavits alone generally. Now, this is a rule that's more honoured in the breach than the observance, of course, but strictly speaking, officials are supposed to say, I have been told by so-and-so and believe this. That doesn't appear an awful lot of at all in these affidavits. It's more, these affidavits consist of officials saying, look at this volume of material that we provided to ministers, and then a minister came to a decision.
Yes, they say this is what the minister had before.
Yes.
In order to make his decision, but there's nothing that says, and the minister told me that this is why he'd made the decision.
That's right. And specifically in relation to that point where the minister has applied the factors, apparently, expressed his decision, it's recorded in minutes, and then the next time they meet, he's indicating he's got a different view, but no reasoning offered for it, and no explanation of how that happened, except that we all know that what's happened since is that the Prime Minister said we should do something different, and he does that. But
I'm not quite sure I understand what is the submission. And you accept that the evidence of the officials is admissible as to what they put in front of the minister.
oh yes, we do accept that.
But you say that. What do you say? And
what we say
infer from that.
We're not trying to make a technical point here.
No, I mean,
not objecting to admissibility. What we're saying is very simple. We're saying that where the court has to engage in heightened or anxious scrutiny of a decision, the court needs the best evidence of the decision makers as to what they did and why they did it. And in this kind of case, it's simply not good enough for officials to do what they normally do in ordinary run-of-the-mill cases where we're talking about departmental decisions as opposed to personal decisions to be made by a minister at the highest level, here in consultation with the Prime Minister and other cabinet ministers. It's not good enough in that kind of case to have this kind of evidence. This kind of evidence is good enough for run-of-the-mill judicial reviews and for departmental decisions, but not the kind of case we're talking about here. So the principle, well, not so much the principle, but the practice of the courts in allowing civil servants to depose on behalf of, in general terms, their ministers can be stretched to a certain point, but not to the breaking point involved here.
You say this submission was made to the courts below, was it?
Yeah, well, the submission was more general, that this evidence isn't good enough to constitute evidence of the decision makers. And we drew attention repeatedly to the distinction that had to be drawn between what the officials were saying on the one hand and what the ministers were saying on the other, or what the ministers believed. And we drew attention both in the High Court and the Court of Appeal to the fact that while we don't dispute the quality of the submissions made by officials and the comprehensive, extensive nature of those submissions, we say that that doesn't allow the court to conclude that the minister came to his decision for the reasons that are set out in the papers. In fact, we were saying the opposite. We were saying that this whole process is a sham. It may not look like a sham. It may have been conducted properly as far as officials are concerned, but as far as the ministers were concerned, this minister started from the point in 2010 where he was saying no more open-ended inquiries, but he's told he has to go through a process and make a proper decision. And he ends up at the point, no more inquiries. But there's been a sort of nuancing of it in between times, because whereas he was headed in the direction of no more inquiries, and no inquiry in this case, the Prime Minister introduced the notion of sweetening the pill by having some kind of review. But the process is not evidenced by what we have here in these papers, because what we have here in these papers is evidence of official thinking rather than ministerial thinking. And so far as we have evidence of ministerial thinking, it simply beggars belief that ministers really believed what they were saying when they said, for example, at the end of the process, the primary objective is to find the truth, when they know that the truth can't be found in the papers. It requires examination of witnesses, most of whom are still alive on the government side, according to the officials. So that's paragraph 89A in relation to costs. And speed, B, it suggests that, as explained by the Secretary of State to Parliament when announcing the decision, the public should not be kept waiting for many more years for the truth to be revealed. But the government, as we say, knew they weren't in a position to reveal the truth without an inquiry where there were powers of compulsion, and people such as the Nelson's handler could have been questioned. Then C, effectiveness. This model, the review model, offered an efficient and effective way of opening up as much as could be opened up swiftly, but not of finding the truth. Over the page, still in paragraph 89, this also offered an effective and satisfactory way of getting at the truth. We dispute that for the reasons we've advanced. The hallmark of effectiveness is independence. Well, it's only one of the hallmarks of effectiveness. And it may be that Sir Desmond de Silva could form a view of the facts, but he was seeking to form a view based on the kind of material that Judge Corrie looked at the facts and decided, I can form a provisional view, but we need an inquiry to come to a definitive conclusion. 90, balancing all of the factors in play and analysed extensively in the ministerial briefings. I think I've made that point. Ministers made an assessment of the public interests, and we'll have to draw inferences about that. They ultimately reached a balanced judgment which is evidenced in the documents. The conclusion is evidenced in the documents, not the reasoning. C, macro-political issue. The facts of this case, the circumstances surrounding the assurances, the range of and nature of the public interest in play, all point to the decision being one in the macro policy or political sphere. Well, the primary objective was supposed to be to find the truth, and the basis of this decision seems to have been that the review was the most effective way to achieve that. Now, this is just not the kind of decision that courts are unable or ill-equipped to assess. But the point is that the political element of this, as I've said before, and I'll try and stop repeating myself, is that this was about the political consequences rather than the content of the decision itself. And then in 94, it says, no doubt there was a personal dimension to the commitment. However, that doesn't alter the public interest aspects. The issues are at the macro-political end of the spectrum, raising, quotes, questions of general policy affecting the public at large. This has nothing to do with general policy. This is about whether there should be an inquiry in circumstances where A, there's been a solemn commitment to have an inquiry, and B, there's an Article 2 obligation, as per McCaughey, to have an Article 2 compliant inquiry. And where the primary objective, according to the decision makers, is to find the truth. There are no multi-layered issues of general policy associated with that. The politics comes after. How are we going to handle the Americans and the Irish and Adams and McGuinness? And then it suggests that the appropriate standard is of review is a Burr-Wensbury basis. Well, whether it's called proportionality or considerations of the fairness or an application of the anxious scrutiny standard, it's a lot more hard-edged than Burr-Wensbury basis. Maybe for an hour debate to engage in the discussion about the semantic differences between these different standards, but it's a lot more than Wensbury. Then there's reference to the United Policyholders case, and it says, issues of foreign policy, in the middle of that paragraph 95, issues of foreign policy and protecting national security also feature prominently in the range of relevant considerations. Well, these were entirely marginal insofar as there may have been any issues of foreign policy. They were certainly not a specified factor, one of the 6 factors. And protecting national security doesn't feature in the record letter, the letter recording the reasons for the ministerial decision, insofar as it does record the reasons. This is some kind of ex post facto rationalisation of this decision and offering reasons that aren't evidenced in the papers. Then fairness and abuse of power. As I say, our case is that this consultation process, this entire decision-making process was a sham, and the representations were ignored. There's reference at 100, page MS 252, to the government confronting the fact that a commitment had been made again. This decision was made on this express basis about finding the truth, that at best, we say, was mistaken, and at worst was known to be false, because a review could never be the best way to find the truth. But there's no indication in the decision letter, such as it is, that the government had squarely confronted this commitment and assessed the gravity of the case and the importance of that commitment. Paragraph 101, no detrimental reliance, he says, not required. 102 at MS 253, the re-engagement with the family had not moved matters forward. The family still refused to indicate whether it would participate in the 2005 inquiry in which ministers had a role. Well, that's just not right, because the matter had clearly moved forward, because the family had gone back and said, all right, we will accept an inquiry under 2005 Act, but what we'd like is the Bahamusa Protocol. And they had understood that this had received sympathetic consideration, and they were given information about the Bahamusa Protocol, which had been operated in the Bahamusa case, so that the minister waived the right under Section 19 to issue a notice and allowed the inquiry chairperson to make the decision about the public interest.
What about the last sentence of 102? Is that accurate?
I'm sorry, my lord?
The last sentence of 102, where they
well, we say it did resolve the matter, because it wouldn't involve the minister making decisions. To issue a restriction notice, the Bahamusa Protocol would have obviated the need for that to happen. But in any event, the family was making clear that it was prepared to operate the inquiry.
But if you operated the Bahamusa Protocol, the chairman of the inquiry could still issue such a notice.
It wouldn't be a restriction notice then, I think it's called a restriction order.
Restriction order, yes.
So it's accepted that there would be circumstances in which certain material wouldn't be made available, but the objection was not necessarily to that. The objection was to the minister. The government minister making the decision, as opposed to an independent chair.
Yeah, thank you.
Seventhly, there are limitations of an ability of an inquiry to uncover every detail. I think the point is that it's the best way to find the truth. As indeed, in fairness, my friend Sir James Eadie has recognised, both in the High Court and the Court of Appeal, that an inquiry is the best way, but this review was a cost-effective way of looking at the papers. Then 104, still on MS 253, refers to the De Silva review and says the process had been invaluable and illuminating. And I want to say that that process was illuminating, and it provided material that hadn't previously been in the public domain. But the main point that arose from the De Silva review was that it reinforced the need for a public inquiry. It didn't undermine it or reduce or diminish it. It reinforced it, because it was clear that things were at least as bad, if not worse, than had previously been suspected. It was apparent that what was required was a proper inquiry where there were powers of compulsion. It's a sham process and predetermination. Said at paragraph 108, this is MS 255, that the appellant doesn't identify any departure from the process indicated by the Secretary of State. Well, that's a surprising contention in circumstances where we have said in terms, both in the High Court, the Court of Appeal and here in our submissions, that the entire process was a sham. But alternatively, when the Secretary of State purported to follow the process, he came up with a certain answer that was dumped unceremoniously without reference to the public interest factors as soon as the Prime Minister indicated a third way. That was the departure from the process, insofar as it's accepted at any level that this process was a real process. And 112, MS 256, the appellant seeks to support factual allegations by reference to views expressed by officials. However, none of these documents amount to any more than an expression of the views of officials. Well, ministers have simply declined to depose to their view, and in the absence of evidence from the ministers, we have to do our best to divine their views from the papers that have been prepared and presented to us. Then Section 6, the HRA and Article 2, and essentially paragraph 114, same page MS 256, it said at letter B that the facts of the case are distinguishable from those in McCarthy. We say that's just not right for all the reasons that we've dealt with. And then there's reference to the European Court decision and the Committee of Ministers. And 122, it said the Secretariat published its assessment. There's paragraph 122 at page MS 260, hard copy internal 47. The Secretariat published its assessment. It was of the view that the Stevens investigation, considered alone, could not justify compliance or constitute compliance, since a full report had not been made available. However, it recommended that the requirements of the public scrutiny and accessibility of the family have now been met, and the recommendation was accepted by the Committee of Ministers, decided to close the case. And at 124, it said the decision of the Committee of Ministers on the 19th of March 2009 was a final resolution on the individual measures. In the Finucane case, the committee was satisfied that the UK had, quotes, taken all the necessary measures to abide by the judgment, unquotes. That's not what the committee said. Those words weren't said by the committee, and there's no evidence of any kind to indicate that those words were used by the committee. Those words that are in quotation marks are taken from a rule of court, and perhaps my learned friends are inferring that because those words appear in the rule, that must have been what the ministers decided. This is an area where it's important to understand the way in which the committee works and the way in which the Secretariat works. And perhaps I should take the court to this material directly. It's in Appendix 3. The relevant part is at hard copy page 969 and MS 1285. Now, what the Secretariat is doing here is addressing the particular issues that arose in the judgment. And as the court will know, the European Court, generally, and in this case in particular, addresses the points that are made at the time, comes to a conclusion on those that it needs to come to a conclusion on, doesn't always address all the issues, but if they've come to a conclusion that there's, say, a breach of Article 2, there may not be a need to resolve other issues. It doesn't prescribe what should happen after they're decision, but leaves it to the Committee of Ministers, which is, of course, a political body composed of the foreign ministers of the Council, the countries comprising the Council. The Secretariat then advises the Committee based on the issues arising in the judgment that have been unresolved. And of course, at all times it's important to remember the context in which these different decisions are made. Specifically, for example, at the time of the judgment of the European Court in the Finucane case, the Stevens investigation was still ongoing, and there hadn't been a conclusion to that. There hadn't been a decision to have an inquiry subject to the recommendation of a judge. There hadn't been the Corey report. None of those things had occurred at that stage. The European Court case concerned the allegations that were made at that time, which included, in relation to Stevens 3, simply the allegation that was not a prompt investigation. There wasn't any allegation about the effectiveness of that investigation because it hadn't been concluded. So the Secretariat is advising in relation to a limited range of issues and deals, first of all, paragraph 134. This is hard copy 969, electronic 1285. Regarding Stevens 3 investigation, the Secretariat disagrees with the position taken by the UK authorities that this investigation is the individual measure in this case. And then it goes on to deal with the question of access, and then looks at paragraph 138 as to whether these particular elements about access to the inquiry, to the investigation, have been satisfied in the subsequent procedures, which included in particular the decision of the PPS. And at 140, the Secretariat therefore proposes to examine as to whether the decision of the PPS and the reasons given by the DPP have satisfied the requirements of the judgment in the case of Finucane concerning access to the Stevens investigation. And 142, the Secretariat, regarding the reasons given by the DPP not to bring further prosecutions, the Secretariat finds the explanations given by the United Kingdom authorities satisfactory. 143, judicial review of a failure to give detailed reasons for a decision not to prosecute is now possible. The Secretariat observes that it does not appear that the applicant has made any application for judicial review, although she argued that she found the reasons given by the DPP vague and unconvincing. And of course, that is at a time when an inquiry had been determined, or had been decided that an inquiry was going to take place, and that inquiry was expected to take place, at which these matters could be dealt with. Paragraph 144. Conclusion. In the light of the foregoing, the Secretariat proposes that the Committee of Ministers may consider that the requirements of public scrutiny and accessibility of family have been met in the present case, which is what this exercise was limited to. It may also consider strongly encouraging the United Kingdom authorities to continue discussions with the applicant on the terms of a possible inquiry. This, of course, says nothing about the effectiveness of Stevens 3, or still less, of course, compliance with the Article 2 obligation as a result of Stevens 3, other than this accessibility point that had been raised in the court case. And then the Committee of Ministers comes to look at the matter. In the case of Finucane, noting that the UK authorities have provided information about the possibility of holding an inquiry, and taking note of other matters, noting the PPS's decision, and no further proceedings brought against any individual, but that no further proceedings should be brought against any individual.
So you're reading from?
I'm reading now from hard copy, page 973, my Lord, MS 1289.
Thank you.
It's under the heading, in the case of Finucane, and this is the decision of the Committee of Ministers now, having considered
so it's the conclusion, yeah.
Yes. So the noted possibility of a statutory inquiry and the PPS decision, and the no application for judicial review has been taken, noting with satisfaction that the UK authorities are currently in correspondence with the Finucane family on the basis of which any inquiry would be established, and strongly encouraging the UK authorities to continue discussions with the applicant on the terms of a possible statutory inquiry, decides to close the examination of this case with respect to individual measures. That respectfully, does not amount to the Committee of Ministers saying they're satisfied the UK has taken all the necessary measures to abide by the judgment. And doesn't amount to the Committee of Ministers or the Secretariat saying the UK authorities have now complied with all their obligations under Article 2. It's about compliance with the issues in the judgment that were raised in 2003. It says nothing about the current state of affairs. But what it does say is, of course, the committee and the Secretariat thinks it's right that the UK government should continue to arrange an inquiry into this. Then at 125, the submissions to MS 261, there's reference to the requirement, the domestic law requirement, to take account of convention decisions, but it's recognised that these all relate to decisions of the court, although the committee is clearly one of the organs in respect of whom the court should take into account decisions. And then 126 at internal page 48, MS 261. It's submitted that this case is a paradigm example of a decision which should be followed in domestic courts. Well, of course, it's not actually any more than a very limited decision concerning the compliance with the judgment. If this court now found, this is about 4 lines from the bottom of the page, if this court now found that Article 2 required a public inquiry, it would also mean that the Article 2 obligations of the UK are more extensive than in the domestic legal order than in Strasbourg. There's just no basis for that at all. If the committee had thought that, it would not have strongly encouraged the UK government to hold an inquiry, or indeed left open the possibility of reopening this case once these proceedings before this court are concluded. It doesn't mean anything of the sort. Then there's reference to the principles, the retrospective reach of the Human Rights Act and domestic Article 2 claims. Paragraph 132, MS 263, deals with McCaughey. And at 133, refers to the principles in Chile and says that the court confirmed that the detachable nature of the Article 2 procedural obligation and identified 3 limitations on jurisdiction to examine pre-ratification deaths. All 3 limitations are met here, as was found by the High Court and the Court of Appeal, and there's some discussion of those, and I think I've made the points already in relation to these matters. I don't propose to labour the matters. This is where there's reference to the 10-year rule. The conclusion is that 141 MS 266 that it's unnecessary to decide this issue in the light of the decisions of the Committee of Ministers that Article 2 obligations have been discharged. You will not find that proposition in the Committee of Ministers' decisions. It is not there. Then application of the principles, paragraph 144, MS 268. The Secretary of State's primary submission is that this case is distinguishable from McCaughey. First ground is there's no inquest. That's why I spent time going through McCaughey, to show that that's not the test, and that's not a basis for distinguishing this case. And it says, and there was no inquiry under the 2005 Act. There was a positive decision not to set up such an inquiry. Before there was a positive decision not to set up an inquiry, there was a positive decision to do exactly that, to set up an inquiry in 2004, which, by virtue of McCaughey, was supposed to be compliant with Article 2. But that's just been abandoned for reasons that we say haven't been properly explained insofar as they could be properly explained, and quite apart from the fact that there has already been a decision to hold an inquiry which ought, by virtue of McCaughey, to be Article 2 compliant. The question is whether the investigations that have actually been conducted post-2000 have complied with the Article 2 obligation that applies by virtue of Shilley, McCaughey, Yanovich, and self-evidently they don't, for all the reasons that we've mentioned about not public, no powers of compulsion, no judicial authority. So 145, several of the judgments in McCaughey have indicated that this didn't have a wider reach. Well, we've gone through these. This is all about procedural steps. Paragraph 146, page MS 269, it suggested that we have somehow made diametrically opposite submissions to the submission that the mirror principle applies. And that's just a misreading of our submission. And in our submission, we were dealing with the KU case and indicating that that was about the critical date for the convention. When the convention applied, and therefore that's why that doesn't apply in domestic law. And then in Roman numeral subparagraph 3 of paragraph 146, we have this suggestion that this is a 10-year rule, which, for reasons that I've indicated, is just not correct. And at 148 suggested we could have had an Article 2 claim in 2006. Well, of course, in 2006 we didn't actually know that preparations had stopped. That only became apparent in 2008 when re-engagement occurred. And then compliance with Article 2 obligations. The core aims of the procedural obligations, in paragraph 149, core aims of the procedural obligations are to ensure proper accountability. That's absolutely right. And there's been none here, literally none, unless you count the getaway driver. Compliance is not formulaic, it focuses rather on the sufficiency and effectiveness of the investigations, and we agree with that. At the end of paragraph 150, page MS 271, it suggested that the Committee of Ministers has decided that the investigations that have taken place met the requisite standards. The Committee of Ministers never addressed the question of whether they met all the requisite standards. The Committee of Ministers addressed the question whether there had been some sufficient accessibility of the family, and that which was resolved on the basis of the PPS decision, which gave reasons, and no more than that. And there's some suggestion at 151 that there's been this uniquely intensive set of investigations, and well, this is all about the, never mind the quality, feel the width. This is a case where they never even interviewed the handler. The extent of the examination of Colonel J is unknown, but the most important point is that no one has actually been held individually accountable for anything. Despite all the admissions and apologies and recognitions of terrible things having happened, no individual accountability. And there's reference to the Committee of Ministers, which have dealt with the various strands of the investigative process. All of these are deficient for reasons that I've already, I think, laboriously explained, and I'm sorry, I'll avoid going back over that ground. And then that takes us to the De Silva review, which of course is post the Impugn decision, but clearly never more than a paper review, never intended to be more than a paper review, a Corrie 2 review with no powers of compulsion, no ability to interview the handler, no public involvement. It's bound to be inadequate for all those reasons. And there's some reference to the scope of that review, and there's reference to paragraph 158. There's MS 275, how he sought and obtained access to a significant volume of material which wasn't available to Curry or Stevens. It has thrown new light on events in a way which he considered to be crucial to his findings, but notwithstanding that, it took literally years for the police to find out, what exactly was the new information. And we still haven't found out. We've got the new evidence here, and we don't object to the admission of that new evidence, but we draw attention to the fact that we still don't know what that new and significant information was. It had something to do with the propaganda initiatives of the security forces. Those are the initiatives that allowed the security service, MI5, to legitimise Pat Finucane as a target. But the police have decided that none of that is evidence of complicity in the murder, and therefore it doesn't yield any fresh investigative opportunities. But insofar as new light's been shed on any of this, not as far as the family or the public are concerned. They note certain important points about the process at paragraph 161, MS 276, including suggesting these are inquisitorial proceedings. Well, of course, the difference between inquisitorial procedures, properly so called, as, for example, with continental models, is that they have powers of compulsion. They're heard in public. There's participation of the victim, and there's generally a judicial figure in charge, none of which is present in this review. At 163, it's said that the report is 500 pages long. It's true, and as I've already recognised that it's illuminating in many respects, but it's not effective. It's not an Article 2 compliant investigation. And significantly, despite being 500 pages long, only 6 pages deal with the responsibility of government. That is, responsibility at the highest levels. And the conclusion is, well, I've seen nothing in the papers that suggests any government wrongdoing, which is not a surprise in our submission, but is not an indication that there is none. Then there are conclusions on compliance. Again, talks about the numerous investigations. Again, this never mind the quality, feel the width point. And then there's reference to Bracknell, paragraph 175 onwards, which I don't think I need to deal with. I wonder if I could just have a moment. I would seek leave to put before the court a letter from Jason Murphy. I should say we have been, since this application for new evidence was made, we have been seeking to ascertain from the police some more information about the content of the new and significant information. And this is the reply. I don't propose to make any submissions about it except to indicate that it doesn't tell us anything new or significant, and still leaves questions unanswered. But we apply really, if we need to, for leave to admit this just to complete the picture that has been introduced by my learned friend.
You happy about that, Sir James? Yeah.
I would like to my friend.
Thank you.
Ladies, Lords, unless there are any other particular matters on which I can assist the court, those are our submissions.
It would really help me if, as I've understood it, the primary objective is accountability, and accountability means prosecution. Is that?
Well, accountability really has two facets. Identification,
yes,
in the first place, and then, if the evidence justifies it, prosecution.
Okay.
Because this is an obligation of means rather than result, as Sir James
So public identification. Public identification,
yes,
and prosecution if the evidence justifies
yes,
it. And what could you spell out in a list the deficiencies of the De Silva review and the cures that would be present in a public inquiry for me, please?
Yes. First of all, there would be a judicial figure that wasn't present in De Silva. Second of all, it would be public. Thirdly, it would have involvement of the family. Fourthly, it would have powers of compulsion. And it's the powers of compulsion that are probably crucial, assuming that the other elements of independence and public accessibility are present. Those are the key features. Ms. Doherty will no doubt tell me when I sit down that I've left something out. No. Those are the key features.
Thank you.
Thank you. Well, does Ms. Doherty have anything to add?
Nothing to add, my lady.
Thank you. Sir James.
I'm going to start with legitimate expectation, if I may. And the short opening submission, you won't be surprised to hear, is that we essentially, subject to one limited point, agree with and respectfully adopt the conclusion and reasoning of the Court of Appeal, and indeed Mr. Justice Stevens' EM was. The sole point of disagreement relates to whether the promise itself was sufficiently clear and unambiguous. And the reasoning of the courts below and the various references into the paragraphs of the judgments we have collated together, hopefully helpfully, at paragraph 9 of our case. Given that everything that this court says is of significance outside the case in which it says it, it may be as well to start with some of the basic principles and where we are in relation to the principles of legitimate expectation, particularly here substantive legitimate expectation. Those principles were summarised.
Sorry, is this substantive legitimate expectation?
Yes, it is. I
You'll
respect it.
explain why that's so.
That's my submission, because it's calling for, it's based on an asserted promise that there will be a public inquiry of a particular kind.
Well, it's calling for a particular form of procedure, which may raise different issues. I mean, I'm not sure whether this has been an issue, but it didn't occur to me that it's obvious that this is a substantive.
That was how all the courts below analysed it, and there's no challenge to that, as I understand it. Of course, it is a procedural benefit, but I do respectfully submit that it's substantive. It isn't just a way of getting to a particular
Right.
a process to get to a particular place. It is an outcome. The principles themselves are dealt with in the first instance judgment between 9 and 21, and the Court of Appeal's judgment between 70 and 75. And we respectfully submit that the principles, in summary, are these. Firstly, the starting point is a careful analysis of the true nature of whatever promise or commitment has been made, and the limits of that nature are set by the repeatedly acknowledged need to establish that it is clear, unambiguous, and devoid of relevant qualification. That, as you will recall, is Lord Bingham in MFK and Lord Hoffman in Boncourt, paragraph 60. And the burden in relation to establishing a promise of that kind and to establish its true nature is on the person seeking to rely upon it. So there's a switch in the burden, as it were, halfway through the process, but the burden at this stage is on the claimant. See Papanet, Authorities 1, tab 3, paragraphs 36 and 37. I'm not going to go to these authorities unless there are particular bits that you want me to, but because they're well known, and I'm simply summarising.
Just give us the paragraphs again, please.
Paragraphs 36 and 37 of Papanet, Authorities 1, tab 3. And the clarity of that promise, we respectfully submit, is to be tested against the circumstances as they have actually occurred. So the relevant question in any case when it comes to court is whether or not it is clear, without ambiguity, that the promise was designed to cover those circumstances without qualification. And that links, we respectfully submit, to the future-facing nature of any requisite promise or commitment. As I think Lord Justice Laws put it at paragraph 43 of the Bat-Murphy decision, Authorities 2, tab 12, the relevant policy's continuance must be assured. That was a paragraph cited by Lord Wilson in the Davis and Gaines Cooper case, tab 16 of Authorities 2, at paragraph 49. Of course, by definition, in the context of legitimate expectation, government always has the ability and always retains the ability to change its view about the policy in question. But in principle, I respectfully submit, it's still necessary to ask separately and as a prior question whether the promise in question is clear, unequivocal, and without qualification in the circumstances that have arisen. would the promise continue? Would it apply in those circumstances? Is the question. So that's the first block of analysis. Secondly, reliance to detriment. The state of the law is, we entirely recognise, in something of a state of flux in relation to reliance on detriment. It is entirely clear from old authority that reliance to detriment is a thoroughly material aspect at the end stage. In other words, in assessing whether the departure from the promise is so unfair as to amount to an abuse of power. But there are indications, and if I may respectfully say so, my Lord Carnwath was not necessarily alone in United policyholders on this. There are indications that it is now being regarded as something closer to an important element of the doctrine itself. Can I just show you that very briefly? Authorities 2, tab 27, I'll give you the MS number in 1 second. Starting on MS 3729. If I can start, if I may, at the back end, at least in terms of order of the judgments. Lord Carnwath's judgment begins on MS 3745. And what follows, my learned friend is entirely right to point out, is to some extent, and in some parts at least, overture, but perhaps the more relevant qualification is the one that my Lord himself gives in the final sentence of paragraph 80, MS 3745. But in truth, what follows reveals, if anything, the modesty of that sentence, because there is then a pretty considered review of the authorities, particularly with a weather eye to seeing whether the Cochran case should be approached in a slightly narrower sense than had previously been thought. And that did require detailed consideration by my Lord of not merely the sweep of case law, much of it, as my Lord points out at paragraph 101, MS 3749, deriving from Lord Justice Laws's repeated analyses on the subject in Nadaraja, Bat Murphy, and the Begbie case that's referred to in paragraph 100. But going across that range of case law, taking in Papanet, as my Lord went, at 104 to 109, but with a view to seeing what the underlying principles of the doctrine were, because that would inform the essential question that my Lord posed, which is whether or not Cochrane should be viewed in a slightly narrower sense than previously thought. And the distinction that my Lord draws, you see in particular from paragraphs 111 to 121 are the key bits, 2 or 3 pages of discussion of the wide-ranging review of the case law, and effectively drawing the sorts of distinctions that my Lord drew attention to in argument today. Namely, when one is dealing with issues of policy, see, for example, 112, paragraph 112 for this purpose, and in agreement with Lord Justice Laws, there are real issues halfway down paragraph 112 if there is a potential conflict with the discretion of public authorities to formulate and reformulate policy. And once one starts abutting onto that territory, once one starts moving into that territory, the courts would be remarkably reticent about interfering. Again, ultimately in agreement with my Lord Justice Laws's analysis in its essence, it would only be exceptionally, that wording I take from paragraph 113, that the courts would intervene. And then drawing the specific contrast in paragraph 117 between the narrow basis of the decision in Cochrane, where a particular promise with all the mutuality involved is given to a very narrow group, in that case a single individual, to do with housing, and the other end of the spectrum involving much wider issues such as matters of national economic policy. And so the case law exists, as it were, on a spectrum, with Cochrane, with its very specific promise, its mutuality of promise, and its a very narrow group to whom the promise is made, is to be contrasted with more general policy type decision making, where you do abut into government being able to formulate and reformulate policy. And in the latter case, when you're at that end of the spectrum, the test is a pretty extreme one for intervention, as one sees halfway down paragraph 117, is the essence of the analysis. I hope I've summarised it fairly. So the contrast existed with Cochrane, and it also existed, as my Lord pointed out this morning, with the factual circumstances as they existed in Papanet. See paragraph 120 for that purpose. That's where I got the reference to similar mutuality of specific commitments. Involved a clear promise by the authority made to a defined group in return for specific action by them within a defined timescale. That's, as it were, the start of reliance, but also mutuality of promise, and designed to further the authority's own purposes. So there's not a contrast, as it were, with the government's ability to formulate and reformulate policy. I'm pointing out that in Papanet, no argument that it raised wider political or economic considerations. And then 121 is really the pulling together of the statements, of the statement of principle. And you see there that the mutuality of promise is a theme halfway through, either in return for action by the person or group, or on the basis of which the person or group has acted to its detriment. So that paragraph is the distillation of the principle that all the previous analysis has been driving towards.
Well, you said that it's a thoroughly important aspect, but if I've understood your submissions, you're not saying that it's an essential prerequisite, that it's acting to detriment.
Well, my Lord, it isn't for me to say one way or the other. The submission that I make is that in the light of this authority, and I'm about to take you to Lord Newberry's judgment, it appears on the basis of A, the statements, and B, the nature of the analysis of the underlying doctrine, that it is a great deal closer to the heart of the doctrine than might previously have been thought. Now,
what is the principle that requires, that underpins the requirement that the promise must have given rise to detrimental reliance? I can well see the relevance of detrimental reliance at stage 2, or its absence as a very weighty factor. But what is the principle underpinning this?
my Lord, I think that the reasoning that leads up to 121 and its references to reliance in 121 is based on the idea that before you can pray in aid, as it were, public law and public law remedies, you have to demonstrate that you are significantly affected in that way by a promise that government has given. So it goes not merely to the fairness of resiling from it, but also to the nature and existence.
Well, no, but I mean, you can be significantly affected by a public law promise without acting detrimentally in reliance on it.
It might be thought that this was a very good example of just such a situation.
Well, my Lord, as I say, you see the analysis that leads to 121. My submission.
You're being put in a slightly unfair position of trying to explain my judgment.
Well, you were certainly not
It's not I'm
explaining.
the but I mean, I do think what I was talking about there was what they call the Kochman principle, and as you pointed out, it goes back to the main point that Kochman itself was a relatively narrow decision. And what I try to explore in the judgment, of course, is the contrast with the sort of wider things one was making policy statements.
That point we understand, but
But that-
Mrs. Coughlin
Yes.
hadn't relied on the promise, actually. She'd just acted on it. She's not
She
quite
had
the same
acted
as
on it,
relied.
and my
Hadn't
lord-
done anything to her detriment other than stay where she was.
Well, I suppose she moved from the hospital that was being closed
Yeah.
to the other premises,
She had.
perhaps potentially in reliance on the undertaking that she wouldn't be moved from them.
Some action as a result of it, and my lord posed...
Detriment is probably
Yeah.
not the ideal
Yes,
word,
but-
as in
It's just, I can well see in
Yeah.
the context of the English law of contract why where you need consideration, why you to found an estoppel you have to have detrimental reliance. What I don't at the moment understand is what is the principle that underpins the requirement for the existence of detrimental reliance when deciding whether there's a promise, the departure from which must be justified.
My lord, I think it is. If there is a principled underpinning to it, it would be that public law will not react unless you can demonstrate as an individual that as a result of the promise, you have taken some action. It is that which makes the promise real, just as. And so, in essence, it's a similar underpinning to the underpinning of mutuality of promise and private law. Can I take you to how Lord Neuberger puts it in his judgment, paragraph 37? And you see the reference in the second line, based on the proposition that where a public body states it will do or not do something, a person who has reasonably relied on the statement should, in the absence of good reasons, be entitled to rely on the statement and enforce it through the courts.
That's quite different, isn't it? I mean, all that's required there is that the person has reasonably relied on the statement. A question of acting to their detriment.
My lord, but it's reliance.
Yes, but
No, but I mean, that's a different case. That's why the majority didn't find it necessary to go down that route. That was a macro-political case. Now I'm suggesting where you have a policy statement in that context, you need reliance. But I mean,
Well, my lord, I'm not going to take up time on it. The reality is...
I mean, for what it's worth, I don't think this case is such. It's not a Cochrane case. It's not a Papanet case. It's a broader policy statement for which, and the issues around that, I mean, I think need to be looked at in their own merits.
But then perhaps one can get to this place, which is, I hope, the way I was putting the submission anyway, which was it's always been accepted that reliance and or detriment is a relevant feature of the fairness of resiling. There is a question as to whether or not it has greater significance, either reliance to detriment or both, as a result of the way in which the principle has been expressed in paragraph 37 and 121 of United Policy Holder. It may well be that this is not the case on which to test that proposition. I've taken it as being a deliberate expression of the principles both in 37 and 121. The third proposition, it is permissible, even if a promise of the requisite nature has been made, for government to change its mind and to change its policy. That legal fact has been reiterated time and again in the case law. Lord Hoffman in Bonku, para 60. Lord Justice Laws in Murphy, paragraph 41, are two obvious examples.
That's not an open-ended permissible, is it?
No, it isn't. That's why there's a fourth proposition.
Yes.
And the fourth proposition is that there must, as it was put, I think, in 118 and 121 of United Policy Holders, there must be good reasons, good policy reasons, I think is the way that's put, in the public interest for departing from their promise. And it is for the court to judge, ultimately, whether it's permissible for the government to resolve. So 118 of United Policyholders and 36 to 37 again of Papanet. There is a question, but it may be an arid question. I'm not going to take up a lot of time on this. There's a question as to whether you formulate that, in other words, the standard against which the court reviews that, as being a proportionality standard or a rationality standard. The reason I perhaps don't need to take up too much time on it is because, again, it might be thought that that all depends on the context. And perhaps as good guidance as any on the way that the courts can and should approach that set of issues is in Bat Murphy. It may just be worth reminding you of that. Bat Murphy, Bundle 2, Tab 12. And it's Lord Justice Laws at paragraph 41. MS 3307. And that was the passage cited and approved by Lord Conn the United Policyholders at paragraph 102. One final word from Lord Justice Laws, if I may. Begbie, and I can take this from a judgment of Lord Justice Lloyd Jones, as he then was in a case called Patel, which is behind tab 22. I think it's bundle 2. At para 61 at MS 3608, can I just invite you to cast an eye down there? He describes, Lord Justice Lloyd Jones in Patel there describes the passage he then quotes from as being particularly illuminating. See the third line of para 61. This was the passage that was heavily relied upon by both the courts below in our case.
Sorry, could you give me a page reference to that? I was busy reading paragraph 42 as well as 41.
3608.
Thank you.
3608. Whilst you're in that decision, it may just be worth, to save me jumping around in the case law, it may just be worth going to paragraph 84 to see the sorts of factors that the court took into account. Paragraph 84 MS 3614. Those are the four principles that are the basics of legitimate expectation, I respectfully submit. And you see there the range of factors that could play into the court's assessment of that against whatever standard, be it rationality or proportionality. Spectrum, the closer you are towards wider issues where government would ordinarily make policy decisions, the more it's multi-stranded, the more it's in macro-political, economic areas, the greater respect, to use the word, courts are likely to formulate and reformulate policy. But in a nutshell, and with that summary, we respectfully submit that the courts below, both the Court of Appeal and Mr. Justice Stevens, applied the correct principles, subject only, as I say, to a question about the nature of the commitment. And can I turn to the application of those principles in our case? It is plain that a form of commitment was given. No one disputes that. It was given in relation to the Western Park proposals, in particular those at paragraphs 18 and 19 of the Western Park proposals in August 2001. If I were to turn them up, I'll read you the relevant bit, which isn't very long. Appendix 2, MS 788, from the hard copy 482, which said in relevant part, in the event that a public inquiry is recommended in any case, the relevant government will implement the recommendation. And the references there to relevant government, you will appreciate, are because this was a bilateral with Ireland. And there are questions as to whether those sorts of inquiries should be set up at both sides of the border. Then in April 2004, Justice Corrie reported and recommended a public inquiry, paragraph 1.293, which you saw this morning, appendix 2, MS 1009, hard copy 703, and see the judgment below at paragraphs 154, Mr. Justice Stevens' judgment to 156. You also saw that Justice Corrie recommended in the next paragraph, 1.294, that what he perceived as being some of the ingredients of the public inquiry. But it is at least to be noted in relation to that paragraph that he was not invited by either government to indicate the precise form or nature of the inquiry, the public inquiry that he might recommend, and there was no commitment as to any particular form by either government. We make three short points in relation to the nature of that commitment, and that's the height of it. Firstly, as to its nature and focus. It had a public element, the commitment. The statements were made in the context of the political solutions put together in Western Park. They were commitments of at least an inter alia, public character designed to address issues of public concern affecting both jurisdictions. See for that point our case paras 45 to 47 and 59. And the commitments were made in effect in that agreement to the other government in the bilateral, the Irish government. It wasn't on any view, therefore, a private promise a la Cochrane. We are and were in the realm of high politics, including on the international plane. And it was in nature a unilateral commitment. There was no mutuality vis-à-vis the family. Secondly, there was no commitment to form or processes. As Mr. Justice Stevens correctly found, and the Court of Appeal agreed, in Mr. Justice Stevens' judgment, it's 163 and 165. And there was, it might be thought, a good reason for not committing to form of inquiry at this time. And that is because it was evident at the time, even of Weston Park, that national security would loom large and would have to be considered and dealt with in the establishment of any such inquiry. And that raised serious issues as to form and process. And again, you'll be very familiar with the nature of the issues, but using PII would have been a thoroughly unsatisfactory mechanism given the degree of national security involved. So one needed to have some mechanism for the person concerned, the person conducting the inquiry, to see all the material without damaging national security. And those issues positively needed to be resolved to enable the twin needs of A, effectiveness, and B, the risks of it collapsing, to be minimised. And the issues simply were not dealt with and could not have been dealt with when the commitment in Weston Park was given, or even when Justice Corrie reported that there was no Inquiries Act at that time.
Now, I've been looking into this a bit, Sir James. There's a report of post-legislative scrutiny by the House of Lords into the Inquiries Act in 2013-14, which gives an account of the genesis of the 2005 Act, which is quite helpful. And in that account, it points to, obviously, the 1921 Act, then the Royal Commission, and then the Salmon recommendations, then the Marchioness inquiry,
Yes.
in which Sir Anthony Clark suggested that the whole process needed review. Then a very brief study by Sir Roy Beldam, which is actually published as an appendix to the next document, which was the government in 2004 published a consultation paper called Effective Inquiries, and they then published a long account of the response to that consultation, and that's what led to the 2005 Act. The Finucane case was mentioned as an example of a case where there were calls for an inquiry, but none of those documents focuses solely or entirely on the Finucane situation. What I have not yet done, because I haven't read them from cover to cover, I've actually been listening and taking notes to everything that's been going on in court, I've just identified them, is to whether this specific point that you are now raising is actually discussed in the government's consultation paper or in the responses. It doesn't feature, as far as I can see, very much in the post-legislative scrutiny. So
I'll double check.
I think it would be very helpful.
Certainly.
To find references to that specific point in contemporaneous thinking.
I think from memory, there was increasing and growing concern about how one could deal with that, both in terms of the previous alternative, which was the 1921 Act, which for present purposes was PII.
Well, yes, but of course predating all of this,
but it was
all the developments in public interest immunity. But
quite, it was essentially PII, which is an exclusionary doctrine.
Exactly.
I think there was also a genuine concern, wasn't there, no doubt building around about this time, as to how one would go about doing inquests in national security cases where you'd end up with PII as the problem as well.
Well, all I'm getting at is that you're making a big thing of the need to have this legislation because it produced a better procedure for dealing with security-sensitive inquiries than the previous procedure, and I'm just thinking it would be good to have some document which which actually discussed that at
My
about
lady,
the time.
we'll see what we can do and
If you could do it.
and chase down whatever materials
It
there
would-
are.
it would
But actually, I make a big point of it. I mean, the point that I make, as it were, is almost a point of principle, which is that under the old pre-2005 Act processes, the alternative, in whatever other process you were dealing with, it be a 1921 Act or an inquest or whatever else it may be, the process otherwise in national security cases risked relevant material not being available to the inquirer.
That is your answer to the appellant's point that it looked as if this new legislation was being introduced.
Ad hominem.
I was going to say feminine.
Ad feminem. I tell you. Yes, but yes.
Or
I mean,
that does not appear to be the case, but the specific point where you're suggesting, in fact, this would be more beneficial to everybody
there's an additional point.
is an additional point. That's all I'm getting at.
Well, we'll see what we can find. And perhaps for the purpose of the legitimate expectation argument, no promise, no commitment as to form. The third and final point then on the nature of the commitment is that it wasn't, we respectfully submit, open-ended and indefinite in respect of future events that might occur, and it can't properly have been understood as such. When made, 2001 repeated 2004, the only reasonable understanding was that circumstances at least could change, and if they did change, they could change in a way that materially affected the public interest balances as to whether or not to set up an inquiry of any particular form. And of course, the further time moved on, the more that point had force.
Well, I've taken up your time, Sir James. It sounds as if you've got to the end of your 3 points as to the
I have.
lack of specificity, as you put it.
I'll give you the punchline of that last point tomorrow morning, if I may, first thing.
Always reserve the punchline till the next day.
Seems safer.
Very well. The court will now adjourn, but look forward to hearing from you at 10:30.